Thank you for the invitation. So I will speak about two or three cases regarding credit reference agencies. And in these cases, I was one of the attorneys for the credit reference agency who was involved. You will probably expect that I will now explain to you why the judgments of the Court of Justice are not right, or why I think they should have made them otherwise. But I won't do that, because one of the things we need to recognize on the European level, and this is very important for this conference as well, is at the end of all discussions stands the European Court. So the question how the GDPR is going to be interpreted, the last word has the European Court, unless the legislator then reacts and decides otherwise. And therefore, these judgments are things we have to deal with going forward. The European Court doesn't like to change its opinion. So there is not much room for further development. And therefore, my presentation will look at what the court has said and how it impacts the credit information or the credit reference agencies, and also other companies or other businesses with similar data protection issues, because all the cases are not just relevant usually for the industry they're made in, as we have seen in prior presentations, but also for the ones that are in other industries but face similar legal issues. I will look at two, or at least I will look at three cases where two cases have been joined into one case. So the cases on data, these are 26 and aus 22 and 64 aus 22. These are looking at legitimate interest and purpose limitation. And then there's another case on scoring that was decided simultaneously in 634 of 21 that deals with automated decision making and data access obligations. I would suggest that we can allow questions after each of the two blocks, because they're quite different subjects. So first, I want to explain to you how credit information agencies work, just to kind of remind you. Most of you have personal experience with credit information agencies or credit reference agencies. And let me just explain that to you. First of all, credit reference agencies receive data from banks, from telecom companies or other companies like mail order companies about the credit activity of individuals. And then they also receive data from publicly available information, from debt collection agencies, or sometimes from consumers as well. There is one main distinction within the European Union, that is that in France, the credit reference agency is a public authority, and that was traditionally for a very long time the case. And then we have in Portugal, we had basically a change in the sense that the central bank developed a credit reference agency that has more or less then alienated the competition in this area in Portugal. And the other countries usually have privately organized credit reference agencies, often in cooperation with the banks. And in most countries, we will find that there's at least one or two of these credit reference agencies, usually not more than 5. And they collect data to allow anybody who wants to enter into a contract that has relevance where the ability to pay back the money is important. The credit reference agencies are requested to basically give their opinion or provide data to evaluate this. The data processing by credit information agencies then usually works this way. There are data sources. The Credit Information Agency collects all the data without having a specific request from anybody. They just collect the data so that they are prepared to answer requests from a bank or somebody else who wants to enter into credit relevant contract. And for that purpose, the data is basically held. It's not data retention as we know it from the telecom area, because the data is usually then still exists in different sources. The data sources will still have the data, and the Credit Information Agency has the data as well. And if there's then a specific request, for example, somebody wants to get a loan, or somebody wants to enter into a contract where they pay but after they receive the bill and not before they receive the goods or anything like that, the requests come to the Credit Information Agency or Credit Reference Agency, and then the data recipient receives that information, and they can basically carry out a credit check on the individual to decide whether they want to enter into the contract the individual was asking for. All of that is to a large degree carried out without the consent of the data subject. The only time usually when a consent is given is if the data subject goes to a bank and asks for a loan, and then the bank wants to make a request to the Credit Reference Agency, then the data recipient or the data subject might have to agree that the bank can disclose to the Credit Reference Agency that a request has been made, and for the purpose of receiving a credit report. We often speak in relation to credit reference agencies about positive data and negative data. And I just want to use the opportunity to explain that maybe it's not always that clear what's positive data and negative data. Positive data, we would say, is, for example, the information that there is a bank account, that there's a credit card, or that there is a contract with a mobile phone company. And negative data would be, well, there was a default, there was an insolvency, or something like that. But if you look at the evaluation of creditworthiness, then positive and negative data are not that clear cut. Because, for example, if you say there's one credit card, that might be positive data, because if you have a credit card for quite some time and you haven't then gotten a default, that would be seen as something positive. But if you have 5 credit cards, that might be seen as an additional risk for a default, and therefore has also negative impact. Also, you also have to see it in relation to all the other information that we have about the person. So if you have a very solid data set, some information that might be positive for most might in that case have a negative effect on the credit rating. So it is quite a complex area. And sometimes I think the courts believe that with credit information that you have the following situation, that you have one piece of data, like one credit card, and that information has a number attached to it, and that you just add up the numbers at the end, and then you have your credit score. This is not how it works. The credit scoring always looks at the complexity of the whole data set, and therefore each entry has different effects depending on the context of the other entries the information has. So the cases on data. So the cases on data we have were 2 cases that are exactly similar, and therefore it was correct of the court to put them into a joint case. And they dealt with a situation where there was a discharge after an insolvency procedure. So if you look at the timeline of this case, there was basically an insolvency. Before there were defaults, but in the public register you would see a insolvency, and then at some stage in the public register you see a discharge entry that says that the debtor has been discharged of all the claims, and it can basically go on with his life. And this information in the public register in Germany is only held for 6 months. So the discharge entry is held for 6 months. This is different in every member state of the European Union. So you have countries where it's held for 3 years, for 5 years, and there are situations where it's basically held indefinitely. If you think back about on the Google Spain case, this was a case where the insolvency was published in the newspaper and therefore effectively available forever. And the case was about the question whether Google would be allowed to still reference that entry that was an entry about the newspaper application. And so the public register is regulated differently in every member state. There's no harmonization of on the European level for how long the information should be there. There's only harmonization in the sense that the European law requires that there is a public notice of the fact that there's an insolvency procedure and there might be a discharge. Then the Credit Information Agency usually has information before the insolvency, because it would register also whether there would be defaults before actually the actual insolvency proceeding happens. And then it will have information about the insolvency. And then in Germany, they took the information about the discharge and kept it for 3 years. And the claim was now about the last part, mainly because the claimant is of the opinion, or was of the opinion, that the moment the data is taken out of the public register, it should also not be available anymore in the by the credit reference agency. So the whole case at the end was about the application of the legitimate interest test and whether the credit bureau, which never relies on consent, but on the legitimate interest test, whether under the legitimate interest test, the credit reference agency would be allowed to keep the information about the discharge longer as it was published publicly. And the court applied the legitimate interest test. So legitimate interest needs to be there, and it clearly understood that there is a legitimate interest for credit reference agencies to process the data. Then there needs to be a need to process the data for this purpose. There was a question in the case whether there is a need to have the data in the database of the credit reference agency, or whether it might be sufficient to leave it where it is, and only if there's a request regarding a person to collect that data. Practically, I don't think that would be possible, but it's certainly a point that now needs to be discussed at the local court level. And then there's a question whether the legitimate interests take precedence over the interests of the data subject. And the court made clear, as it always does, that the court is not responsible for applying this test, but it can give some indications or what should be taken into account. So it applied the balance of interest test, said, of course, there's a legitimate interest. It also specifically referred to the legitimate interest of the contractual partners of the credit reference agency that will then have the ability to access the data. So the credit reference agency doesn't have to just say, well, we have a legitimate interest, but it is also relevant that the contractual partners of the credit reference agency have a legitimate interest to receive such data or have the ability to receive such credit reports. So that in total was relatively positive for the credit reference agencies. Then it went into the test of the necessity, and it said no alternative way with less impact should be possible, and that test should be made together with the test on data minimization and the and it also considered the question that the credit reference agency has whether the credit reference agency has to can collect the data in the first place, or whether they should wait for a request by the relevant contractual partners. They basically referred it back to the national court to look into these aspects further. But I think it should be noted that the test itself is of legitimate interest, is further developed by the court, and this has basically has consequences for all other businesses as well when these type of considerations are made. However, the court made clear it is for the national court to exercise the balancing test and then come to a conclusion. However, the court went a little bit further than it would usually go, because it said that in this case, the German legislator provided that information relating to the granting of the discharge of a discharge from remaining debts is kept in the insolvency register for only 6 months. And then it says it therefore considers that after the expiry of the 6 months period, the rights and interests of the data subject take precedence over those of the public to have access to that information. So the court didn't just say it's for the national court then to access the balancing, to do the balancing exercise. It effectively gave a clear indication that the fact that the German legislator decided that the data should only be publicly available for 6 months should, in the balance of interest test, should be taken into account, and that would probably lead to the conclusion that the data has to be deleted after the 6 months. This is was a little bit surprising in the sense that we thought that the balance of interest clause would be always interpreted the same in the entire European Union. And by putting such emphasis on the opinion of the German legislator, the court basically disregarded the fact that every legislator, or most legislators in the European Union, have taken different views. I think there's no other legislator who said that this information should only be published for 6 months. As I said before, there are legislators who basically have 3 months, or have 3 years or 5 years. And so somehow the opinion of the German legislator for the European court seems to be very important. But the question then is, does that only apply to Germany, or would the opinion of the German legislator be also applied in Italy, Spain, or everywhere else where the data is available for much longer? The second aspect the court didn't look into, but would have maybe been important, was the purpose limitation aspect. And the Advocate General looked into that and asked the question whether there is an issue with purpose limitation if data is taken from a public register in to the data set of the credit reference agency. And the purpose limitation says that the data has to be collected for specific explicit legitimate purposes and then not further processed for incompatible use. And that issue has been dealt with in a different decision in the Digi case. And but in the Digi case, we had a situation where a company decided to use data further for other purposes. So it was within one controller who would process the data further. So this controller, Digi, had collected the data for specific and legitimate purposes and then wanted to process them further for testing purposes and so on. In the case of the credit reference agency, the government collected the data and published it in a public register. And then the credit reference agency collected the data for the purpose of the credit reference agency and processed it further. So the question that remains open is, did the court not look into purpose limitation in the credit reference case because it believed that the purpose limitation doesn't apply, because it was a new collection, if you want, by the credit reference agency? Or did it not look into this because it thought it had the question will be already answered based on the legitimate interest test? And if you look in recital 50, it says that if you further process for compatible purposes, then you can rely on the original legal ground for the processing. And that shows, I think, that maybe a new collection by a new controller puts a break into the purpose limitation provision, because otherwise the credit reference agency wouldn't have had to rely on the balance of interest clause. It would have had to rely on the legal provision that allows the German courts to publish the information about the discharge, because that was then the original legal ground. So legal provisions around the managing basically of insolvencies and the publication of data around it in German law. And if then the credit information agency would have claimed that it is a compatible further processing, they would have been able to rely on that legal ground. And obviously that can't be, because the legal provision doesn't apply for the credit reference agency. So I personally believe that case shows that purpose limitation is not relevant here. Instead of going through purpose limitation, you have to find the legal ground for the processing, which the court did. But it didn't really explain this. So there's still room for maneuver for the court to decide to what extent purpose limitation applies. Does it apply in a way that once the data is collected by somebody, that purpose has to kind of live through in a compatible way, even if the data changes from one controller to another? Does the purpose limitation only apply within one controller and the further processing by that? And that would be the Digi case. So this is still an open issue. And but the fact that the court went straight for the balance of interest clause and didn't consider purpose limitation, I think is an indication that maybe purpose limitation doesn't apply if data is processed from basically one controller to another, and that every collection starts the purpose limitation new. So consequences, For credit reference agencies, well, they have to delete the data from public registers, usually if the retention period under national law expires, until there's anything else in national law that would say otherwise. It is quite interesting in the sense that in Germany, when the period was for the publication was set to 6 months, the political discussion around that was mainly as follows. The politicians said, well, if taking into account that the data is still available at credit information agencies, we only have to publish it for 6 months. And now the European Court says, well, if you publish it only for 6 months, the credit information agencies can't have the data for longer. So now there would be basically room for the national legislator, I suppose, to say to set another deadline basically for the credit information agencies. But I haven't seen anybody trying to do that, also not in Germany. So I suppose we will have a situation where every country effectively has then different retentions by the credit reference agencies, because they have different retentions in the public register, which obviously doesn't help to have a unified framework in the European Union, but that's it. And then for others, well, the case shows that there are high standards for legitimate interest, and I would point out that the necessity criteria seems to be getting a much broader implication, maybe as we thought it would be. In the Netherlands Tennis Association case that came out, we see that the court speaks about the requirement that the data processing has to be strictly necessary to be able to rely on the legitimate interest test. So we will see how this goes further. All right, then the case on scoring. Same day judgment, same parties mainly involved, so that this wasn't surprising, and that it would be on the same day. And this case deals with scoring. And so what happens is somebody requests a credit, for example, at the bank, and then the credit reference agency is asked for a credit reference. They provide data about the data subject, like how many bank accounts the data subject has, how many loans, and what type of loans, and credit cards and telecom contracts, and whether there's information about debts and everything, as I explained at the beginning. That information is given to the bank, and then there's a calculation of a score. The score usually would tell the bank the following. It tells the bank, if you enter into this contract based on our past experience, we would say that there's a risk of a default of X%. So if you have a score then that's calculated for this situation of 95%, there's a risk of 5% that there might be a default during the process. It doesn't have to be a full default in the sense that they never get the money, but basically a default in the sense that the payment is not made in time, or not. So what the court now looked at is the scoring bit carried out by the credit reference agency. And it looked at it because the data subject wanted to have detailed information about how the scoring works. And in order to get that, they went to the Data Protection Authority. The Data Protection Authority said, no, credit information reference agency isn't obliged to provide the information, and even if they are obliged, they have already given it. And and then this case went to court, and the court made the reference to the European Court. So the European Court had to look at Article 22, and Article 22 is actually a provision that has had very little impact over the years. It's a provision that was already in the Data Protection Directive, and as you said, I was already involved in data protection before the directive even was passed. At the time, I was also kind of consulting to some degree the European Commission. I was an assistant at the university in Würzburg, and Article 22 was, as far as I understood it at the time, an idea of the French government. French government was concerned about situations where benefits granted by the government were withdrawn based on purely automated decisions. And this provision basically that would give the individual the right to get the automated decision reconsidered. And at the time, I already thought this has nothing to do with data protection law, but it went in and therefore also was kept in the GDPR, because the GDPR wasn't, the intention of the GDPR was not necessarily to change the directive, but to add to the directive. And so Article 22 we have, and it's about automated decision making that's based solely on automated processing, including profiling, and has a legal or similarly significant effect for the data subject. And why has this provision almost never been used in practice? Well, most of the decisions are not solely automated, and a lot of decisions that are solely automated don't have a legal effect or significant effect, or just a significant effect to the data subject. So if you look at the bank loan, the bank would say, well, we always have a person involved in the decision, so it's not solely automated. You could, with respect to a bank loan, say, well, if you apply for a bank loan and you don't receive it, that doesn't have any effect on you, because you are basically, after that decision, exactly in the same situation as you were before, because so you didn't have a loan before and you still don't have it. But the legislator in the recitals made clear that it would apply to credit evaluations, and in this case now we're at the situation where the data subject wanted the information from the credit reference agency and not from the bank. And the credit reference agency certainly calculates these scores purely on an automated basis. There's no individual involved. So we did have a case that would where Article 22 would apply. The main question was whether it should apply to the credit reference agency, because credit and reference agency doesn't decide over the loan, whether it's granted or denied. It only decides what score it provides, and then the final decision is made by the bank. So the court that referenced the case said, the Administrative Court of Wiesbaden said, well, there's a problem, because if the data subject goes to the bank will say, I can't tell you how the score is calculated, because that was done by the credit reference agency. If the data subject then goes to the credit reference agency, the credit reference agency says, well, we won't tell you either, because we haven't made the decision. And the court was concerned that there was a gap then in the protection. And that gap was closed by a different decision by the Federal Administrative Court in Austria, in the sense that they said, if a bank uses a credit reference agency to calculate the score, then the bank has to make sure that they can also provide the information of the logic how this score is calculated. So the Federal Administrative Court, the Court of Austria, basically created, if you want, a one-stop shop. They didn't reference the case to the European Court. They just said, well, it's clear if the bank uses a score, for an automated decision according to Article 22, then they have to be able to provide the necessary information, Article 13, 14, and 15, with respect to the score.
Sorry for the interruption.
In Wiesbaden,
I think your
yes?
connection is a bit choppy. And we've been losing you a bit in the past couple of minutes.
That is unfortunate. Not entirely sure how to solve that. I'm directly connected to the with a cable basically to the internet, so it should
now it seems to be
okay.
okay. It fluctuates a bit.
Yeah.
Let's see. Yeah, if you can repeat a bit the information you shared on this slide.
Yeah. Okay. Okay. So the point on about this slide is we basically had two solutions for the European Court they could have followed. One was the Administrative Court of Wiesbaden solution, which said, well, the data subject has to be able to go to the credit information agency and ask how the logic of the score is. And then we had the solution by the Federal Administrative Court of Austria, who said, no, the data subject can go to the bank to ask about the logic of the credit scoring, but then the bank has to be able to provide that information, and if they need to, they have to go back to the credit information agency and get it. So but the court basically followed the consideration of the court in Wiesbaden and said, no, the information has to be given by the credit information agency. That isn't a kind of a big problem for the credit information agency, because they have always given that information. But whether that has to comply with Article 22 and Article 13, 14, and 15 is then clear from a European court point of view. They have to comply with this provision, and it's not just a voluntary information they give. So but the other problem with this case, apart from providing the information, are the other effects of Article 22. Article 22 has a prohibition for the processing of the data. So generally it says you cannot process personal data for automated decision making that has a negative effect on the data subject. That is not allowed unless one of the derogations in Article 22 applies. And the first derogation is that the decision making is necessary for a contract with the data subject. And one of the problems here is that the credit information agency doesn't enter into a contract with the data subject, only the bank does. So now the question is, can the credit information agency still rely on this derogation because it's providing the data to the bank who wants to enter into the contract with the data subject? Then the other derogation is it has the processing should be authorized by union and member state law. German legislator has now introduced a provision that would authorize the scoring by credit information agencies. So that is a possibility, but most member states don't have that yet. And the third one is consent. So do we need to ask the data subject to consent in the decision-making process using scoring, or is that basically too complicated in this process? And the effect is that even if it's necessary for a contract or you have consent, that the data subject has a right to obtain a human intervention regarding the decision. And that is a slight problem with the credit reference agencies because they can't give you the loan. So if the data subject can only go, and that's the decision of the European Court, can only go with respect to the scoring to the credit reference agency, the credit reference agency wouldn't be able to give the data subject what the data subject wants at the end, and that is the loan from the bank. But this is how the court decided. So I believe that the Austrian solution was probably easier because with respect to these effects, because there the bank can rely on the fact that the data subject wants to enter into a contract, and the bank can then review the decision with the human and to make a decision whether to grant the loan or not. But so the way the European court sees it is more complicated, but obviously manageable. So what the data subject in our case wanted was information about the logic and the significance of the processing. And the main problem the main issue we will see going forward is what means meaningful information about the logic. And that will be decided in another case done in Bradstreet, Austria, 203 from 22. That case is pending. The Advocate General has issued an opinion on the 12th of September. So this year, I suppose, we will get a decision. And the Advocate General opinion is quite interesting because one of the main questions is providing meaningful information about the logic. Does it mean you have to provide information about the actual algorithm that's used to make the automated decision? And the Advocate General says, no, you don't have to do that. Meaningful information about the logic has to be something less technical and understandable for the data subject. But still, there seems that it needs to be sufficient to make sure that the data subject has all the information they need to go back to the controller and say, reconsider the decision. So they need to be able to challenge the scoring or automated decision that is gone on based on how it was calculated. In practice, that leaves a lot of question open. So I will be very interested to see how the European Court will finally decide on that. But I think the Advocate General is correct that meaningful information about the logic doesn't mean the algorithm. And the Advocate General therefore says, well, then it also means that this information usually doesn't impact trade secrets because it doesn't capture the algorithm, but the Advocate General then also looks more in detail to what extent trade secrets or copyright or something like that could restrict the information that has to be provided. So the consequences for the credit reference agencies at the moment are they have to give notice themselves and provide access to the information about the logic and the underlying data. To my knowledge, the credit reference agencies usually have done that, but they believe that it was voluntary. The court makes clear this is directly an obligation out of the GDPR. If the information then is used for to make the decision by the bank without human intervention, and the credit reference agencies have to work a bit on how they apply the derogations of contract and consent. One solution might be that the scoring is actually carried out as permission data processing for the banks. Or first of all, one of the solutions could be the credit information agencies only provide the data to the banks, and the banks then calculate the score. That would mean that the obligations would be only with the bank. And then the second step would be, could the banks then use the Credit Information Bureau with respect to the scoring as a processor? That is actually the existing concept in some of the member states, including Spain, for example, and carry it out. That would basically mean that the Austrian solution would come back, and the European Court decision would have no effect. But we will see how the industry and the legislators react. As I said, the German legislator is putting in some law. The European legislator could do that as well. So we will see how whether the credit information agencies try to rely on derogations or make the scoring and activity the banks carry out. And for others, I think the decision has a significant impact on other types of decisions. Well, they have to be negative for the data subject. They have to have substantial consequences, legal consequences or otherwise. But if you look at the use of artificial intelligence usually makes automated decisions, and they can be used for something that's negative for the data subjects. So Article 22 could apply. And that would mean that the main legal provision we have in the European Union to regulate artificial intelligence is not in the Artificial Intelligence Act, it is in the Data Protection Regulation. And therefore getting Article 22 out of its beauty sleep through these decisions of the European Court might mean that there's going to be more of a notion to consider artificial intelligence, the use of artificial intelligence in that respect. And if you then ask the question, how do you explain the logic of a decision that's made by artificial intelligence to the data subject, becomes very daunting, because it's basically based, like with the Credit Information Agency, it's based on a lot of data, and often we simply don't know how artificial intelligence comes to a certain conclusion. So so being able to explain the logic other than referencing to Wikipedia's page on what is artificial intelligence will be quite challenging. So we will see how the European Court gets out of that dilemma. But specifically also because it would apply to companies that provide artificial intelligence, also in cases where they don't make a decision that's negative for the data subject, but the users of the artificial intelligence tools would make these decisions. So so it's going to be very interesting how this develops further. When the Artificial Intelligence Act was discussed, I suggested to delete Article 22, but obviously the GDPR is a holy grail of the European Commission, so nobody would be allowed to do that.